Good evening to everybody, the JCJ aspirants of the 2022. Karibu sana, welcome to my class, and read what I posted on the screen. Anyone can unmute, only participants. Anyone can unmute and read.
Choice questions on Hindi law.
And you did not read the Hindu Marriage Act and the Hindu Succession Act. And host Sri Vidya Matamari, Kolikunda Sharat Babu, Professor Hussain. Now the first turn is I'm going to give to the Kolikunda. Be ready, Kolikunda, for now I'll switch over to you. I believe that you are present.
Yes, sir. Good morning.
Good morning. Continue it.
First question is, in 2008, the Supreme Court ruled that the Hindu Succession Amendment Act 2005 has dash effect, and for the daughter to become a co-sharer with her male siblings, the father does not have to be alive on 9th of September 2005. A. Prospective. B. Introspective. C. Retrospective. D. Imperative.
Prospective A.
Perspective.
That is not correct.
Second option.
Retrospective, sir.
Yes.
Option
Retrospective.
Sorry, retrospective. Sorry. Yeah.
With retrospective. Option C is the correct answer. From the back date, that means. So, second question is, for the purposes of the Section 6 of the Hindu Succession Amendment Act 2005, partition means any partition made by execution of a deed of partition duly registered under the Registration Act 1908, or partition effected by A, a decision of a court, B, a decree of court, C, a judgment of a court, D, an order of a court.
Decree of a court, sir.
An order of a court.
Yes, option B is the correct answer, a decree of court. Now, third question is, a Hindu cannot create an estate unknown to Hindu law or lay down deed of settlement of his property, a line of succession against principles of Hindu law of inheritance. This was decided in the case of A. Ashwini Kumar versus Asha Rani, B. Rabindra Prasad versus Sita Devi, C. Basappa versus Siddhagangamma, D. Brijendra Pratap Singh versus Srimati Premalata Singh.
Ashwini Kumar versus Asharani.
Wrong.
Option C, Basappa versus Siddhagangam.
That is also wrong. Any other option?
No, B and D.
Option D is the correct answer.
Option D,
Vijayendra
sir.
Pratap Singh versus Srimati Premalata Singh. Now, fourth question is, where there was no partition by metes and bounds between common ancestors, order decreeing with direction to partition suit properties is just and proper. This was declared in the case of A. Hari Sahu versus Dinabandhu Sahu, B. Angelos Uran versus Kamal Uran, C. Ravindra Kumar versus Kamal Kanta, D. Jacinta Kamath versus Padmanabh Kamath. Shoot your answer. Shoot at any option.
Option C, sir.
Option D is the option A is the correct answer. Hari Sahu versus Dinabandhu Sahu. Hari Sahu versus Dinabandhu Sahu. If the partition is not done by metes and bounds, then the court will give an order to do it so. Fifth question. The Hindu Section Amendment Act 2005 amended the earlier Act of 1956, revising rules by giving daughters of the deceased equal rights with sons on A. Individual property, B. Self-acquired property, C. Co-personary property, D. Jewelry and cash.
B. Self-acquired property.
C co-personary
Personary
property.
Yes,
Option
option
C,
C is the
co-personary
correct
property.
answer, co-personary property. Now, sixth question is, the Hindu Succession Amendment Act 2005 amended the earlier Act of 1956, giving and subjecting both male and female children A. Equal rights and same liabilities and disabilities, B. Equal rights, C. Equal duties, D. Same liabilities and disabilities.
Option A. Equal rights, same liabilities and disabilities.
Yes, option A is the correct answer. Equal rights as well as same liabilities and disabilities. Now, seventh question is, according to the Hindu Succession Act 1956, the class 1 heirs do not include A. Sons, B. Daughters, C. Father, D. Mother.
C father.
C.
Yes,
Father.
option C is the correct answer, father.
Let the host
Eighth question.
read the D option.
According to which
Then only that you can give the answer.
D. Mother. D. Mother. Option C is the correct answer. Next, eighth question is, according to which section of Hindu Succession Act 1956, the Act does not apply to certain properties? A. Section 6, B. Section 1, C. Section 7, D. Option is Section 5.
Section
D.
Section 5.
Yes, option D is the correct answer according to Section 5. Now, certain properties cannot be succeeded. Ninth question. The descendants of converts from Hinduism are disqualified from succession as per dash of Hindu Succession Act 1956 unless they are Hindus at the time of succession. A. Section 21, B. Section 20, C. Section 26, D. Section 22.
Section 26. Section 21, sir.
Sandhya Lavanya, mute.
Yes, option C is the correct answer. Section 26. According to Section 26, the converts are not disqualified to inherit the Hindu succession property.
Custody of child.
Next, 10th question. If an intestate has left no ultimate heirs as per the provisions of the Hindu Succession Act 1956, such property shall devolve on the government, which is called A. Bona vacantia, B. Escheat, C. Eminent domain, D. Confiscation.
B estate.
B. Escheat is the correct answer. Option B is the correct answer. Now, 11th question. The Hindu Succession Act 1956 abolished A. The limited estate of Hindu man, B. The limited estate of Hindu father, C. The limited estate of Hindu woman, D. The limited estate of Hindu mother.
Option is C, the limited estate of Hindu women.
Are you sure?
Yes, sir.
Yes, sir.
Yes, option C is the correct answer. The limited estate of Hindu woman. 12th question. The Hindu Succession Act 1956 pertains to A. Hindu intestate or unwilled succession, Hindu intestate or unwilled succession, B. Hindu willed property succession, C. Hindu testate property succession, D. All of the above.
All of the above.
Option A, Hindu intestate or unwilled succession.
Yes, option A is the correct answer. Hindu intestate or unwilled succession. 13th question. Parts of the Hindu Succession Act 1956. So scroll it down. Parts of the Hindu Succession Act 1956 were amended in A. December 2004, B. October 2004, C. December 2005, D. October 2005.
December 2005, sir.
December
C.
2005.
Yes, option A is the correct answer. December 2004. 14th question. The Act number of the Hindu Succession Act 1956 is A 39, B 45, C 30, D 24.
39.
30.
A,
Option C, sir.
39.
Option
sir,
C,
39.
30.
C option.
Yes, option C is the correct answer. Someone has said option C is the correct answer. 30, the Act number. 15th question. The Hindu Succession Act 1956 was enacted on A 1st of June 1956, B 1st of August 1956, C 16th of August 1956, D 17th of June 1956.
Option D.
Option D.
17th June
1956.
1956.
Yes, option D is the correct answer. 17th June 1956. Now,
16th.
16th question is, sir, it's not clear. According to the Hindu Succession Act 1956, there are dash of heads. A, 3 classes, B, 2 classes, C, 5 classes, D, 4 classes.
B, 2 classes.
Two
classes.
classes.
Option B is the correct answer. There are 2 classes of heirs according to Hindu Succession Act 1956. Now, 18th question. Your father's sister's son
No, you
son
missed
would
the
be,
17th.
oh, sorry. 17th question. Section dash of the Hindu Succession Act 1956 disqualifies a murderer of the murdered person from inheriting his property. A, 27, B, 22, C, 25, C, 23, D, 25.
D25.
Yes, option D is the correct answer.
A, 27 is
25,
the answer.
section 25. According to section 25, a murderer is disqualified from inheritance of the person. Now, 18th question. Your father's sister's son would be A, full blood related to you, B, half blood related to you, C, cognate to you, D, agnate to you.
D. Agnate to you.
D.
Full blood.
C. Cognate.
C, option C is the correct answer. Cognate to you. 19th question. The order of succession of heirs in the Hindu Succession Act 1956 is stated in the section A, section 9, B, section 25, C, section 13, D, section 10.
Section 10, sir.
Section 9.
Yes, option
Nine.
section 9 is the correct answer. Option A is the
Section
correct
9 is
answer.
the right answer.
Section 9. Now, 20th question. Section 21 of Hindu Succession Act 1956 is provided for A, assumption in cases of simultaneous deaths, B, confirmation in cases of simultaneous deaths, C, determination in cases of simultaneous deaths, D, presumption in cases of simultaneous deaths.
Option D.
Option D.
D is the correct
In case of
answer.
simultaneous death.
Option
Yes, option D is the correct
Option D is
answer.
the right answer.
It is a presumption in cases of simultaneous deaths. Now, 21st question. One's father, comma, father's father, comma, grandfather, comma, grand-grandfather are one's agnates in A, collateral line, B, ascending line, D, C, descending line, D, horizontal line.
Option B.
C, descending line.
Descending line.
Option A, sir.
Option A is the correct answer, ascending line. Now, 22nd question is, when two persons are descended from a common mother by her different husbands, then their relationship according to section 3(1)(e) of the Hindu Succession Act 1956 is by A, half blood, B, full blood, C, uterine blood, D, none of the above.
C.
Uterine
Uterine blood.
C, uterine blood.
Option C is the correct answer, uterine blood. Now, 23rd question is, there are dash chapters and dash sections in the Hindu Section Act 1956. A, 5 and 31, B, 4 and 31, C, 4 and 32, D, 5 and 32.
5 and 31.
Option
5 and 31.
4 and
A.
31.
Option A,
5 and 31.
5 and 31.
Option B is the correct answer, 4 and 31. Of course, fourth one is repealed, but anyhow, when they are, we have to say how many chapters, we have to say 4 and sections are 31. Now, 24th question. Section 3, Clause F of the Hindu Section Act 1956 defines A, succession, B, inheritance, C, sapinda, D, heir.
C. Sapinda.
B. Inheritance.
D. Inheritance.
Option C, Sapinda.
D. Hair. Hair, sir.
Option D is the correct answer, heir. 3F defines heir. Heir means warasud, successor. 25th question. After the Hindu Section Amendment Act 2005 came into effect on 9 September 2005, Class 5 of section shall not apply to the parties affected before. A, the 20th day of December 2004. B, the 20th day of January 2005. C, the 20th day of February 2005. D, the 21st day of December 2005.
Option A.
A.
Sir.
20th December 2004.
Yes, option A is the correct answer. The 20th day of December 2004. Thank you, sir.
Yes, now it's a turn for the Motamari Srividya. Are you ready?
Yes, sir.
Yes, now go through it. Just scroll down. Yes.
First question. When did Hindu Marriage Act 1955 came into force? Option A, 1st April 1955. Option B, 1st March 1955. Option C, 1st May 1955. Option D, 18th May 1955.
Option D.
Option
18th
B.
May
18th May 1955.
Yes, option D is the correct answer. Next question. Which section of Hindu Marriage Act 1955 deals with the restoration of conjugal right? Option A, section 12. Option B, section 9. Option C, section 14. Option D, section 20.
Section 9.
Option B. Section 9 of the Hindu Marriage.
Yes. Third question. Which section of Hindu Marriage Act deals with the divorced person when may marry again? Option A, section 15. Option B, section 14. Option C, section 13. Option D, section 18.
Option A. Section 15 of the Hindu Marriage Act.
Yes, option A, section 15 is the correct answer.
Option A.
Fourth question. Sir, please scroll down.
Yeah.
Section 25 of Hindu Marriage Act 1955 deals with option A, decree in proceedings. Option B, permanent alimony and maintenance. Option D, option C, disposal of property. Option D, enforcement of decree and orders.
Option B.
Option B. Permanent alimony and maintenance.
Very good. Fifth question. Proceedings to be in camera and may not be printed or published is provided in section dash of Hindu Marriage Act 1955. Option A, section 24. Option B, section 22. Option C, section 21. Option D, section 23.
Option C.
Section 22 of Hindu Marriage Act.
Section
Section B.
Yes, section B, option B, section 22 is the correct answer. Sixth question. Section 16 of Hindu Marriage Act 1955 provides option A, legitimacy of children of void and voidable marriages. Option B, decree in proceedings. Option C, punishment of bigamy. Option D, divorce by mutual consent.
A answer. Legitimacy of a child of void and voidable marriages.
Yes, option A is the correct answer. Legitimacy of children of void and voidable marriages. Seventh question. Which section of Hindu Marriage Act 1955 deals with the custody of children? Option A, Section 27. Option B, Section 24. Option C, Section 26. Option D, Section 29.
26.
Option
C.
Supplementary question. Section
Option
26 is the correct answer. Option C is the correct answer. What is Section 27?
Disposal of property.
Yes.
of property.
Avoidable marriages.
Eighth question. Section 12 of Hindu Marriage Act 1955 deals with option A, avoidable marriages, option B, consent and verification of parties, option C, disposal of property, option D, divorce.
A.
Avoidable marriages.
Yes, option A is the correct answer. Ninth question. Which section of Hindu Marriage Act 1955 deals with the court to which the petition shall be presented? Option A, Section 17. Option B, Section 19. Option C, Section 14. Option D, Section 15.
Option B, Section 19.
19. Section 19.
Option B, Section 19 is the correct answer. 10th question. Section 10 of Hindu Marriage Act deals with option A, alternative relief in divorce proceedings. Option B, decree in proceedings. Option C, judicial separation. Option D, enforcement of decree and orders.
C.
Judicial separation.
Yes, it's very good. These are direct questions. Everyone are very thorough with Hindu Marriage Act. And 11th question, which among the following are source of Hindu law? Option A, Shruti. Option B, Dayabhaga. Option C, Mitakshara. Option D, Co-Personary.
Shruti.
Option C.
Option
Option C.
Option D is the
Shruti is the
answer.
correct answer.
Option D is the answer. Co-personary, there is no such thing.
Okay.
Option A is the correct answer. It's Shruti. 12th question. The provisions of mutual consent divorce is mentioned under option A, Section 13, option B, Section 13B, option C, Section 14, option D, Section 15.
13B.
Option B, 13B.
13B.
Yes, very good. Can someone name the famous case laws of Section 13B?
Sarita versus Venkata Subbaya.
Pardon?
Sarita versus Venkata Subbaya.
Versus Venkata Subbaya. I think it's related to RCR.
Give the answer.
That is not
Harvinder
mentioned.
Kaur versus Harvinder Singh, sir.
Repeat.
Harvinder Kaur versus Harvinder Singh.
Okay.
And Ashok Hurre versus Rupa Hurre. It's regarding divorce by mutual consent, one of the famous case law.
Proceed.
Next question, 13th one. Cheat is a term employed to denote lapsing of property to the dash in default of heirs on the death of the intestate. Option A, NGO. Option B, government. Option C, orphanage. Option D, none.
Option B, government.
Yes, option B, government is the correct answer. 14th question. When two persons are the descendants of a common ancestors, but by different wives, they are said to be related by each other by option A, full blood, option B, half blood, option C, uterine blood, option D, either B or C.
Option
B.
half blood.
B is the correct answer. The common ancestors, but by same wife.
Full blood.
Full blood.
Yes. If it is by same wives, it is full blood. Different wives,
blood.
half blood. Yes, yes. 15th question. A partition as per Mitakshara law may be effected. Option A, by agreement. Option B, by notice.
Voice
Option
is
C,
breaking.
contract. Is it clear now?
It's clear to me.
Okay, sir.
Proceed.
Yes, all the above is the correct answer. 16th question. The age of bride and bridegroom under Hindu Marriage Act 1955 are option A, 18 years and 21 years. Option B, 21 years of the both. Option C, 18 years of both. Option D, 20 years and 22 years.
A is correct.
18 and 21.
Yes, option A is the correct answer. 17th question. A male Hindu dies in an accident. A is survived by his wife, father, son, and daughter. He has not made a will. How will A's property devolve as per Hindu Succession Act? Option A, equally to his wife, father, son, and daughter. Option B, equally to his wife and father. Option C, equally to wife, son, and daughter. Option D, all the property goes to his father.
Option C.
Option C.
A.
Option C.
Equally to his wife, father, son, and daughter.
Yes, option C is the correct answer, equally to wife, son, and daughter. 18th question. Can an unmarried Hindu girl of 25 years adopt a boy of 10 years under the Hindu Adoption and Maintenance Act? Justify your answer. I think Hindu adoption is not there in today's syllabus, sir.
Yes.
Okay, go to the next.
19th question. A decree of divorce was passed between A and B. 19th question. A decree of divorce was passed between A and B. A celebrates second marriage with C within 6 months of this decree. This marriage is option A valid, option B voidable, option C void, option D invalid.
Valid.
Valid.
Option A.
Yes, option A valid is the correct answer. 28th question. Sir, please scroll.
Yeah.
In case of an offense of dowry death, should have occurred within dash years of her marriage. Option A 5 years, option B 12 years, option C 7 years, option D 10 years.
C.
Option C. 7 years.
7 years.
Option C 7 years is a 21st question. Only ground available for dissolution of marriage under the Special Marriage Act 1954 is option A impotency, option B adultery, option C cruelty, option C desertion.
Desertion.
Option C, cruelty. Impotency.
Option A adultery is the correct answer. It's regarding Special Marriage Act 1954. 22nd question. A marries adultery, option B. 22nd question. A marries B, the widow of his elder brother. The marriage is option A valid, option B void, option C voidable, option D none of the above.
Valid.
Voidable.
Voidable.
Read the question again. It's valid marriage. A marries B, the widow of his elder brother.
Widow. A.
Yes, sir. Option A is the correct
Valid.
answer. 23rd question. Marriage between an unmarried woman and a married man is option A irregular, option B none of this, option C voidable, option D void.
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 Irregular.
Option C.
Repeat the question. Can you repeat the question now?
Marriage between an unmarried woman and a married man is
Void. Irregular.
Option B, none of these. It is by
Option B, none of this.
who said option B?
Void.
Can you explain why this is none of this?
Voidable.
It's void.
It is voidable if the wife of a married man petitions complaints, then it will become voidable.
The answer is none of this, sir, but I don't know the correct explanation. None of this is the correct answer.
I think voidable is
Give the justification.
because unless the wife of a married man complains about this unmarried woman, then it will sustain. There are many examples in the cine field also.
Host,
Yes, sir.
what do you say?
They can even be in live-in relationships, so it would be none of this. Only question comes when they quarrel each other or any petition comes to the court.
That's why I think I say it is voidable.
Void.
It is a wide
Valid.
Yes,
Already
sir,
man
we need
The
to
host
again.
decision is
Yes,
final.
sir.
As per section 5, condition for the Hindu marriage is a wide.
void ante.
Yes, sir. I think it's wide, but it's again point of doubt. Tomorrow I will clear this.
Yes, section 5 of Hindu
but
marriage
what is
act
the
clearly says that.
But can anyone tell what is
Proceed,
the difference?
24th. Host,
Yes, sir.
24th.
Yes, sir. 24th question. In which of the following case it was held that Hindu husband converting to Islam and marrying again will be guilty of bigamy? Option A, P. Venkatramana versus State. Option B, Saroj Rani versus Sudarshan Kumar. Option C, Sarla Mrugda versus Union of India. Option D, Dr. N.A. Mukherjee versus State.
Option
option C, Sarla Mudgal versus Union of India.
Yes, yes, correct answer. Can someone give
It
me
is a
facts of
famous
the case?
case.
Yes, sir.
Proceed.
Yes, 25th question.
Yes. Can someone give explanation regarding P. Venkatramana versus state? Sir, 24th question, sir. Please scroll down. P. Venkatramana versus state of AP.
Say pass on.
It is regarding-
Host will give the answer.
Pass on.
It's
Don't
regarding
waste
the
the time.
age of the yes, sir. It's regarding the ages of the bride and bridegroom. At the time of marriage, both are minors. So when he became major, he just thought of divorcing. It was regarding such principles, sir. Regarding Section 5 of Hindu Marriage Act. The marriage was considered void ab initio.
Is this explanation about 24 with P. Venkatramana versus this?
Yes, yes.
But the case is Supreme Court held that converting for the sake of marriage to Islam is not acceptable.
Actually, for
Actually, for 24th, the answer is Sarla Mugda. But I'm just
Sarla
giving
Mugda.
explanation for P. Venkatramana versus state.
No.
Okay. Thank you.
Yeah.
Proceed 25th.
25th question. Which of the following is a leading case on desertion? Option A, Kailashwati versus Ayodhya Prakash. Option B, Ashok Hura versus Rupa Hura. Option C, Bipin Chandra versus Prabhavati. Option D, Bhagwati versus Bhagavat. Bhagavat versus Bhagavat.
Option C, Bipin Chandra versus Prabhavati.
Yes, Bipin Chandra versus Prabhavati is the correct answer regarding the case of desertion.
Yes,
Yes, sir.
supplementary question. What is meant by desertion?
Continuous period of 2 years.
Living apart.
2 years.
Only one can make it out. Spandana, speak.
Wife or husband, anyone living separately for 2 years, more than 2 years. 2 years or more than 2 years.
Consecutive.
Sir?
Consecutive 2 years.
2 years.
Don't say 2 years.
Continuous. Yes, sir. Continuous 2 years.
The wording is very much important.
Desertion, actually, it is abandoning.
Correct. What you said is correct.
And what section says Hindu Marriage Act?
Legitimacy of your child in void and voidable marriage.
I said the desertion, what section says? On the grounds of the dissolution of marriage, there is a section and clause 1 clause is there.
Section 13, class B.
13, class 1A.
1A or 1B?
1B.
1B.
Anyway, check it.
1B is the correct answer, sir. 1B.
Yes, check it. Now it is my turn. Hindu Marriage Act 1955. And let us see that you are giving answer for all the questions immediately. Now let us see how you give the answer for this one. First question. Let me make the first. What is the purpose of Hindu Marriage Act 1955? Which one is false statement among the 4 options? A. The main purpose of the act was to amend the codify the law relating to the marriage among the Hindus and others. B option. Besides amending and codifying the Sanskrit law. And C. It is also included separation and divorce, which is also exists in Shastric law. D is, because I don't want to show the feedback. D is, this enactment brought uniformity of law for all section of Hindus. I said which is false for the purpose of the Hindu Marriage Act of 1955.
Option C, sir.
Wrong.
Option C.
Option A, sir.
A is wrong.
Option B, sir.
You are giving the chorus answer at the time. Now no chorus answer.
Option D, sir.
Wrong.
Option
What is
A.
left?
C is left.
What is left?
B is left, sir.
Besides amending and codifying, there is no Sanskrit law. Besides amending and codifying Shastric law, Sastrik.
Oh, Sastrik.
Now you give the answer for this question. Second question. Let me put the numbering. At the time of the marriage, there is no subsisting valid marriage between any of the party. That is, the provision of the act prohibits bigamy or polygamy and polyandry. These are all treated as an offense and are punishable under the A, the Hindu Marriage Act, B, the Hindu Succession Act, C, the Indian Succession Act, and D, Indian Penal Code.
Indian Penal Code.
Indian Penal Code, the option.
I appreciate. It is the Indian Penal Code says regarding the
Hindu Marriage
polygamy
Act.
and polyandry. Supplementary question. What is the bigamy case law? I mean section?
494.
I appreciate. So, when a living spouse is there, you are not supposed to conduct the marriage at second.
Unless you get converted into Muslim.
Oh, you choose the options. No options only you have to choose from there. No assumption and presumptions. Okay, next question. That is the third question. Match the following acts from part A and corresponding year in part B. So now, let us see. Number 1, Hindu Marriage Act. Number 2, Hindu Succession Act. Number 3, Indian Succession Act. Number 4, Special Marriage Act. And part B, 1955A, 1956B, C, 1925, D, 1955. And now you choose which is the correct. Of course, I did not mention the options here. If I mention the option, you can easily make it out.
The only thing is the Special Marriage Act is 1920.
I said participants, not the host. When I say host, you should have to appear.
Indian Marriage Act.
Option A. Indian Marriage Act.
Only one can
Special
speak.
Marriage Act 1998.
Special Marriage Act 1954, sir.
Special Marriage Act 1954.
There is no 1954 is written there, I believe. Is it written? I think there is something missing. Okay, now let me consider it.
1955.
Okay, now let us consider it. Okay, 154 we can make it out instead of 55. Okay, next. Next.
All are correct, sir.
You have to say because we are reading Hindu Succession Act of
1956, sir.
and the Indian Succession Act 1925.
1955.
Special Marriage Act 1954.
1954.
Then what is the right option?
55.
Here you say
Hindu Succession Act.
Hindu Succession Act 1956.
56.
Hindu Succession Act is 1956, Indian Succession Act 1925, the Special Marriage Act 1955, the Hindu Marriage Act of 1955. Okay, now in the actors, Saif Ali Khan married. Which type of marriage? Saif Ali Khan married Kareena Kapoor. Which type of marriage it is?
Special Marriage Act.
Dharmendra married Hema Malini. Which type of marriage it is?
Hindu marriage.
Hindu marriage. And Saira Banu married Dilip Kumar. Which type of marriage it is? Tiger Patodi married that Sharmila Tagore. Which type of marriage it is?
Special marriage.
I think all these are the special marriages.
No.
Special marriage.
No. Tiger Patodi married according to the family law. That is the Muslim law.
Shamila Tagore converted into
Yes, yes,
Islam.
yes. And here I am giving some cases. Let us see that what are the cases would be there is important cases. Yamuna Bai, Anantarao, Aadhar versus Anantarao, Tirar Rao, Aadhar. And this is the case law where the Supreme Court held that if there is any subsisting valid marriage between any of the party at the date of the time, the marriage is considered void. That is the notable case law. Please note down. Because it's already there on screen, you can see it, and I load it also on the YouTube. Next
Now it is certain, sir. The answer for the earlier question we were in doubt.
Yes.
So if an unmarried woman marries a married man, then it is certainly a void marriage.
Yes. Supreme Court held that if there is any subsisting valid marriage between any of the party at the date of the time, the marriage is considered as a void marriage unless until divorce is taken over there.
Yes, that's
The next case law, Ajit Roy Shiva versus Bai Basmati. I repeat, Ajit Roy Shiva versus Bai Basmati. In this case, the time of the marriage, wife was unaware of the fact that the person to whom she was married was lunatic, and the marriage were happening. She came to know that her husband was lunatic. So the court held that this marriage is voidable at the option of the aggrieved party, that is the wife in this case. A question will be asked to the principal, and they will give the different cases. Among them, the right case law is lunatic married. At the time of the marriage, the wife doesn't know. But later she came to know that she is a lunatic. At the time, option given to the wife for the voidable marriage. Case law name is? Yes, that is the case law. The next is case law Shakuntala Devi versus Amarnath. In this case, Punjab High Court held that marriage performed in this case by way of custom and usages, and therefore in this case, Section 5, Subsection 4 of the Hindu Marriage Act 1955 is not applicable in this case because
Custom.
it is a custom and usage marriage. That means custom and usage marriages are valid marriages in India. What is the name of the case law? Shakuntala Devi versus Amarnath. Next case law, Swapna Ghosh versus Sarananda Ghosh. The court granted divorce to the aggrieved party as her husband had committed an offense of adultery. Of course, now adultery is no more a offense. At the time, it is an offense, and hence we can use this Swapna Ghosh versus Sadanand Ghosh. In which case law?
Adultery is still a ground for divorce.
It is a ground, but not the offense. I say offense. What is the name of the case law?
Swapna Ghosh versus?
I said adultery is not an offense.
Joseph Shane versus
Joseph Shane versus
Union of India.
not state of Kerala.
Union of India.
Joseph Shane from
Kerala.
Yeah. India is a diverse country, and India family law does not vary from state to state. A single system of law directs every community, even if the community members are settled, domiciled, or resided in any part of the country. A single law system will govern them, but there may be variation in the law related to the caste, subcaste, or subsects. It is based on the custom which create the variation among the groups. Hindu Marriage Act applicable to whom?
Hindus.
Who are the Hindus?
Hindus, Buddhists, Jains, Sikhs.
And not the tribals.
And which section says?
Sikhs also. Sikhism also considered under the
Section?
2.
I appreciate. Yes, now let us see the Hindu Succession Act of 1956 multiple choice question. Then the first question is, Section 2 of the Hindu Succession Act lays down the applicability of the act. This act is applicable to which one is false statement among the four? A. Any person who is not a Hindu by religion or any of its forms or developments include the Vairashaiva, Lingayat or the Brahmo or Prarat or the Arya Samaj followers. B. Any person who is a Buddhist, Sikh or Jain by religion. C. Any other person who is not a Muslim, Christian, Parsi, Jew, unless it is proved that such a person would not be governed by the Hindu law or custom. D. The act shall also extend to the whole of India.
Option C.
Option C.
Option C.
Why C is the wrong answer? Tell me.
Because
Option
these
A.
are the religions which are exist. Option C, Muslims, Christians, Parsis, Jews, and here these are not governed by the Hindu law, as well as these are not customized in our Hindu culture.
So that is the answer for that one.
No, sir.
Actually, if one is not a Muslim or
Yes, sir.
Christian or Parsi or Jew, that doesn't mean that he is a Hindu.
Option A.
Option A, sir.
I put is not a Hindu by religion. Option A is the false.
Correct answer. Option A is the correct answer.
Option D, sir.
Okay. Second question. However, this section, the above section 2, shall not apply to any scheduled tribes covered under the meaning of dash of the Constitution unless otherwise directed by the central government by a notification in the official gazette. Option A, Article 363. Option B, Article 364. Option C, Article 365. Option D, Article 366.
Option D.
Article 366. Option D.
You are right. It is the Article 366 is the right answer for the second question. Now the third question. Who qualifies as a Hindu, Sikh, Jain or Buddhist? It means which is the correct statement among the four statements. A legitimate or illegitimate children where both of his parents are either Hindus, Buddhists, Jain or Sikhs. B option. A legitimate or illegitimate child, one of whose parents is a Hindu, Buddhist, Jain or Sikhs and is brought up as a member of the tribe, community, group or family to which such parent belongs. C. Any person who is a convert or a reconvert to the Hindu or Sikh, Jain or the Buddhist religion. And D. All of the above.
All of the above.
D. All of the above.
All of the above.
Please check once again.
All of the
Option D is the right answer.
Can a illegitimate child be taken into consideration as a Hindu?
Yes, sir.
Qualifies as a
Yes, sir. Consider as a Hindu.
Okay.
Yes, sir. Illegitimate children, provided one of the parents is a Hindu, is certainly a Hindu.
Option D, all of the above, sir.
All of the above.
D, all of the above, sir.
Okay. Let's check it once again. Fourth question. Match the following, taking one each word explanation is given in the section part B. From part A, agnate, cognate, hairs, related. Section 3.1F, Section 3.1I, Section 3.1A, Section 3.1C. And here the option A, 1A, 2C, 3B, 4D, B, 1B, 2C, 3D, 4A, C, 1C, 2D, 3A, 4B, D, 1B, 2D, 3A, 4C.
Option C.
Option C is the right answer.
Option C is the right answer.
Option C.
Feedback. Agnate, Section 3.1A, Cognate, section 3(1)(c). Hair, section 3(1)(f).
Hair.
Related, section 3(1)(I). Match the
Sir,
following from A. The relation in part B.
a clue for it, sir. Agnate A, cognate C.
But I gave the feedback. No, why you are again asking me? See, feedback I am very much clear.
To remember it, sir, I am saying.
So you are showing the mnemonics.
Yeah.
You are showing the
3(1)A
mnemonics.
for Agnate, C for 3(1)C.
Okay. 3(1)C. C is a
I,
cognate.
sir, it's J.
And A, agnate. 3(1)A, agnate. Of course, if you two remember it, we can easily make it the deductive method. Is it clear? Shall I proceed? At any time it will stop. Fifth question. Match the following part A, the relation in part B. Class 1 hairs, the class 2 hairs, the class 3 hairs, fourth class 4 hairs. In the part B, father, son, a cognate. Class 4 is someone who has related to the interstate through the mixed relative in terms of the sex, and this consists of the agents of the disease. It is very much clear it is given because first two you know it, the other two it is already self-explanatory. And here 1A, 2B, 3C, 4D, 1B, 2C, 3D, 4A, 1D, 2B, 3A, 4C, D, 1B, 2A, 3D, 4C. Which one is the correct answer?
Option D.
Option D is the correct answer here.
Option D, sir.
Yes. So when you see the feedback, class 1 hairs, sons will come. Class 2 hairs, father will come. Class 3 hairs, the consist of the agnates of the deceased. And the class 4 hairs is concerned, a cognate, that is the class 4 is someone who has related to the interstate through mixed relatives in terms of sex. What is meant by interstate? Participants.
A person who dies without writing any will.
I appreciate. The Indian Succession Act will be applicable to whom?
Intestate persons.
For the Jews, for the Parsis, for the Christians, for the Muslims?
For only Hindus.
For the testate, for intestate?
Intestate.
Yes. Now the question comes. If a person married under the Special Marriage Act, what succession law could be applied over there?
Indian Succession
Indian
Act,
Succession.
1925.
It is the Indian Succession Act will be applied over there. Can you both Muslims undergo the Special Marriage Act?
Yes, sir.
Answer is yes. Because it says, without caste and creed, the marriage will be conducted not only in India, but also in foreign country, if the both are
Indians.
Indian citizens. Where in the foreign country, where the marriage will be celebrated, conducted?
Embassy, consulate.
It is the concerned embassy or the High Commissioner. Of course, depending upon the countries, either we can say High Commissioner, or we can say embassy, or we can say diplomat. So these are the things which I want to share today. And because at any time it will stop, I don't know why the Cisco WebEx is very kind enough. Otherwise, it's only 50 minutes. The time given is only 50 minutes.
Due to more number of participants, sir.
So the more number of participants are there, they want to give the subsidy. Okay, not more number, because yesterday there are 75 is there. Today it is a 54 or 54 or 56 is there, the highest. I don't know how many members you have taken the screenshot when the highest number is present over there. What is the highest number today?
54, sir.
You have not taken the screenshot because I am busy in admitting the students, those who are coming late. So tomorrow class is
4.
CPC.
CPC,
On
in type of the abbreviation, which type of the abbreviation it is?
Code
I
of
told you
Civil
in the yesterday, 4 type of the
Civil
abbreviations.
procedure code.
Short form.
CPC, which type of the abbreviation?
CPC tomorrow or
Participants.
day after tomorrow, sir?
Code of Civil
Date mentioned.
Procedure law.
Initialism. When you say tomorrow, if it is holiday, under the General Clause Act of 1896, the next working day.
The next working day is treated as work. Yes.
Under the General Clause of Act, it is say, suppose if it is clearly mentioned who crosses the red signal, he will be charged fine. A woman crossed the red signal and she says, I am not she, I am not he, I am she, hence the section is not applicable to me. Answer is, he includes she. Who says? Who says?
General clauses, sir.
General Clause Act, you will say. And female single.
Now the third gender is also included.
Yes, now the third gender also comes.
Does it apply to that gender?
What is the name of the case law? Where the third gender is also be considered. What is the name of the case law?
Navatet Singh.
No.
No. There is no homosexual.
Nelsa.
National Service Authority versus Union of India. National Legal Service Authority versus
NLSA versus Union of India.
And where one of the organization, which is the Inuk organization, Hijra organization, also a party there. And that case law, he, she includes transgender. So, thank you very much for your participation, and we will meet on next as per the schedule is concerned. The schedule says CPC on, what is that? Hindu marriage, yes, it is 24th is a holiday and 25th is Monday. Thank you very much. Let me say goodbye. Have a nice day.
Goodbye, sir. Thank you.
And Jai Hind.
Thank you, sir.
Thank you, sir.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full